questions as we possibly can. I'd like to talk about what this meeting is about and what it's not about. The meeting is about conveying information that the State Division of Oil and Gas, the State Water Board, the Governor's Office, and US EPA have agreements that we have made over the last few months, and how the state will become compliant with the Safe Drinking Water Act over a short period of time. With me today are Rob Habel, who's the Technical Services Manager at the Division of Oil and Gas, Scott Couch, who is the Section Head for groundwater protection at the State Water Board, and David Albright, who's the head of drinking water protection at US EPA Region 9. The afternoon lays out as follows. We're going to have three presentations, each from one of these gentlemen to my right. They will present essentially a body of technical information. Because the presentations build on one another, we're going to hold questions until the end of the presentation, because it's very likely that questions that might be raised at the end of the first presentation will be answered by one of the subsequent presentations. We'll then entertain questions from the audience, and how I'd like to structure that is to first take technical questions, questions of clarification about what the presenters said. Then we'll take a little bit of a break, and then I know there are people from the press here, I know there's students here, I know that there are heads of organizations that have advocacy positions are here, and we will do our best to answer those questions. So we'll have presentations, we'll have technical questions and clarifications, we'll take a short break, and then we'll return to answer questions of a more general nature, and we'll try our best to answer those as best we can. So thank you for coming, and my pleasure to introduce Rob Habel. We'll start the afternoon off.
Thank you, Steve. So basically, the order that we're going in is very similar to the order in which an application for primacy would go through the process, starting with the Division of Oil and Gas. And so basically, we're trying to cover several things in this presentation. Basically, where we've come from, basically how we got to this point, where did an aquifer exemption come from, and then go through a little bit the process that we're using now, and we call it an interim process to get us up into compliance with the Safe Drinking Water Act. So basically, the Safe Drinking Water Act was passed in 1974, and part of the act, it tried to clarify what was going to be protected as far as an underground source of drinking water, and they came up with 10,000 milligrams per liter total dissolved solids. Also part of the act, it required the US EPA to develop regulations in which to implement the act, and part of those regulations broke the different types of injection wells, because there's a lot of different types of injection wells out there, into, at the time, it was 5 classifications, it's now 6. We're just focusing on the Class 2 disposal wells, Class 2 injection wells, includes both enhanced oil recovery and disposal. And the Class 2 basically is anything associated with the production of oil and gas. And so also there were a couple paths forward for states to apply for what's called primacy, whereby allowing the state to regulate the underground injection programs locally, many under their own existing regulations and statutes. And that's the one that the state of California applied for. Basically, it's Section 1425 of the Safe Drinking Water Act, as opposed to another path forward, which is to adopt all the requirements that the US EPA had developed in their regulations. So the state was very involved in injection for many years before for the Safe Drinking Water Act. And so we want to continue to be very involved in the injection process, the approval process. So we applied for primacy and submitted our application in 1981. Basically, it was based upon our program in 1981. And we included some supporting data of where existing injection and production was occurring in the state. As a result of all that, and when the EPA, through research of our data and discussions with us, we came into an agreement which was then memorialized in a memorandum of agreement. So, even though I don't expect you to read this, but on our website we have a copy of the primacy application. And so basically this is a document that gives an overview of the state's program of how we regulate injection wells. And it's on our website. You can take a look at that and have a better understanding of what our overall program is, not just the aquifer exemption of which we're discussing today. Even though I'm not expecting you to read this, this is just like the front page of our memorandum of agreement, which again was signed in 1982. I believe it was ratified by the EPA in March of 1983. In addition to the application that you can find on our website, we also have a couple other documents that were part of the application. We had the oil and gas fields, volume 1 and 2, which delineate where production was occurring at the time of the application. These documents are different parts of the state. One was published in 1973 and the other one in 1974. But this gives a basic overview of where production injection was occurring in the state. And in the document, it talks about what's in the document and how you need to read and actually use the document. And so, going back here, what was circled basically is on this next slide here, which talks about where the productive limits are in the oil fields at the time of primacy. And this is important because if you're having any enhanced oil recovery injection going on, it's going to be in those areas of where it's being produced. And so basically you'll see, I'll give you some examples in a moment, that to delineate where the production was at the time, it'll either be by symbols showing where the producing wells were, or it actually has kind of a shaded area that outlines what the productive limits are. I'm going to get some more detail of what that actually means. So I'm going to zoom in some slides coming up, but this is sort of like one of the sheets that we have. It actually has a map view of the oil field, and then typically we also have a cross section. And as you notice on these, you'll see the shaded area right there, as well as in the cross section, you'll see some shaded area. That's what we're referring to as the productive limits of the oil field. Also, on the other, associated with those maps, there's also data listing the productive zones and some information about those productive zones. And so, from the previous slide that was circled, it goes into basically talking about what the producing zones are in that field. And so you'll see the zone listed over here with some information as depth and thickness and the age and so on. And so that's a way to help delineate where the productive zones were in the oil field at that time. Going back to the map view, again, some of these fields are very complex, and there's a lot of geology that we need to evaluate when we're regulating oil and gas fields. But again, the shaded area that you'll see here outlined basically is outlining at that time what the productive limits of the field were. And you have to realize that it's just not one zone that's producing. Many times there's multiple zones in the field, which we'll see here on the cross section. That you see in the cross section, those areas that are shaded, those are the productive limits. So even though this is within, let's say, the overall shaded area, that zone right there is not productive at the time, and so we wouldn't consider that a productive zone. So you see there's multiple layers, and I'll explain to you now. Basically, even though you have the shaded area, and this is just a made-up field, that let's say this is the productive limits of the field. It's made of multiple zones within that, and basically when you're looking down on it, the outer edge of all those that are stacked on top of each other constitutes what the overall shaded area is. And you can see some of these other ones right here could be individual zones that are productive. But so not everywhere underneath the shaded area necessarily means that it's productive. And so you could have in this oil field 2 wells being drilled all within the shaded area, where 1 well is in the productive zone, where the well in red isn't necessarily the productive zone, even though it's in this shaded area. So let me show you a little video here. So this is basically showing the shaded area from the surface, and now we're going down to look at it in a 3D image to show where the different individual producing horizons are. So there's one here, you can see these as they turn. And so this well right here is actually completed into the productive horizon, where the one that we had outlined in red is not. And so that is not a productive area. So in order to do injection in this zone, we would have to meet some criteria that we'll get into in a few minutes. Again, you have to realize when we're going through the aquifer exemption process that we identified that an underground source of drinking water is any zone that has water quality of 10,000 milligrams per liter total dissolved solids or less. And so if any of these zones that let's say we're showing are greater than 10,000, then an aquifer exemption would not be required based upon the Safe Drinking Water Act. But if it's less than 10,000, then we have to look at that. And again, the reason why I'm focusing on the productive zones, that's where the majority of injections occurring in the state for enhanced oil recovery. Okay. So let's get into the aquifer exemption criteria. And I want to preface this a little bit that I'm going to be going through the process that goes through the Division of Oil and Gas, the State Water Board, and then ultimately to the US EPA. I'm going to be covering briefly what goes on in the other agencies, focusing mainly on what the Division of Oil and Gas is doing. But we need to be aware of what the Water Board is looking at as well as EPA, because ultimately it has to go through the approval process to obtain an aquifer exemption. So basically the criteria is set forth in 40 CFR 146. And the biggest hurdle that you have to get over to apply for an aquifer exemption is that the zone that you want to have exempt can't be used currently as a source of drinking water. I want to note for you to note that the Safe Drinking Water Act is a federal requirement, and they're looking at protecting drinking water. California also has mandates to protect water, and we're looking at this at a little higher bar, which is water for beneficial use. So if someone is pulling water out that is using it to water their pistachios, it may not be suitable for drinking water, but definitely is suitable for farming. That's a beneficial use. So that the aquifer is currently being drawn upon for other uses of benefit, then it can't pass the first bar, which is it can't currently being used. If it's currently being used for beneficial use, then the process is going to most likely dead right there because it's currently being used. And we don't want to contaminate any waters of beneficial use. But if you get past this hurdle, the next one is it won't be used, not as not being used now, but it won't be used in the future. And that's broken down to different categories. And this brings us to why I was mentioning the oil and gas producing zones. Is if it's a hydrocarbon producing zone, then that's one of the thresholds that you can use to apply for primacy, in that no one's going to be drinking water that's produced with oil. There'll be high levels of benzenes, toluenes in that, and so you wouldn't be using that. That's one of the reasons why that qualifies for an aquifer exemption. So if you're not hydrocarbon producing, then you have some other options. So one of the options is that if it's at a location that it's not feasible to access, it's too deep, that you can't recover it then that could be one of the other categories you could be using. The next one is that even though the TDS level is at, let's say, less than 10,000, there could be other constituents in the fluid, the water, that render it not usable for beneficial purposes. If you have a zone that has a TDS between 3 and 10, and you can show that it's not reasonably expected to supply a public water system, that's also another criteria that you could be using. So let's go through the aquifer exemption process. So I first gave you kind of what the criteria is. Let's kind of go through the process. So we have some zones, right? We have some wells that are injecting some zones that require some aquifer exemptions. And so the division basically will be asking the operators to help supply the information. We have a lot of information ourselves, but in some cases, if you want to do an aquifer exemption that's going to extend the producing limits of the field, we're going to need some additional information to support those claims. So we work with the operator so that they can provide us with some supporting documentation so that it meets the criteria that we're looking for based upon the criteria from US EPA and the regulations. So the division will be looking at the supporting documentation and we'll be evaluating to make sure it meets the threshold. Now, the heavy lifting for the division is if it's a hydrocarbon producing zone, that's really our burden to carry. If it's going to be used, if it's a zone that's not hydrocarbon producing and it's not hydrocarbon producing, it really falls to the water board. Take a look closely at that. So first you have to look and do a survey around the area to make sure that there's no wells drawn from the same aquifer. It's not being used for beneficial purposes. And we have to make sure that, you know, what gets a little cloudy, a little difficult is how far out do you go?
Excuse me?
Yes.
I'm a Long Beach citizen and a resident, and I'm wondering, are you teaching people how to continue poisoning our drinking water, how to get around?
Excuse me, we'd like to take that question later after the technical presentations,
I
please.
did want to ask, there will be time for questions.
Yes, yes.
How much time will there be?
Considerable amount of time.
What?
Considerable amount of time,
Thank you.
yeah.
Okay. So again, we have to make sure that there's a survey done of the area that you're looking to exempt to make sure that water is not being drawn from that. And so, you know, if not just in the area that you're looking at, if for some reason the injection would cause the migration of fluid off the area that you're working in, then that's a great concern too. So it's not just in the immediate area, but it's in the surrounding area. If this water is going to move in a certain direction.
No, I'm sorry, I just have to say one thing. This is backwards. It was just announced in the news that the industry injected 2,500 wells illegally, and Dogger admitted that they didn't know this was going on. Shouldn't you be having a workshop on how to stop that instead of how to get around, to get exempt from these regulations?
Actually, we have a compliance agreement with EPA that we will discuss as part of these presentations. I really would prefer that people not interrupt these presentations. This is not about having a protest while we're trying to get something accomplished.
Well, I actually brought Tonos poison water to show everybody what we're going to be exposed to and forced to drink if this poisoning of our water by our regulators continues. So, would you feel like drinking this water? Here.
Excuse me, ma'am. Excuse me. We will have.
Excuse me. Try this water and tell us if you feel like drinking the water that you're polluting for our children and for us, and that you have been allowing it for so long. You're the regulators.
This needs to stop! You are our regulators. You have violated your mission. We hereby serve you your pink slip. Thank you. We, the people of California, fire you from your post. Shame on you for colluding with big oil, our aquifers. In this year of record drought, in this era of a warming planet, it is reprehensible that you are teaching them how to exploit our laws to poison our water.
Our aquifers are not toxic waste dumps.
1, we are the people. 2, you can't ignore us. 3, we will not let you poison our water. 1, we are the people. 2, you can't ignore us. 3, we will not let you poison our water. 1, we are the people. 2, we will ignore us. 3, we will not let you poison our water. 1, we are the people. 2, you can't ignore us. 3, we will not let you poison our water. 1, we are the people. 2, you can't ignore us. 3, we will not let you poison our water. 1, we are the people. 2, you can't ignore us. 3, we will not let you poison our water. 1,
We are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people too. You can't ignore us. 3, we will not let you poison our water. 1, we are the people. You can't ignore us. 3, we will not let you poison our water. 1, we are the people. Shame on you! Shame on you! Shame on you! Shame on you! Your job is to protect us, not to poison us. Shame on you! 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 Ban fracking now! Ban fracking now! Ban fracking now! Water fracking now! Ban fracking now! Ban fracking now! For our children's health! Water can be poisoned for private wealth! We will fight for our children's health! Water can be poisoned for private wealth! We will fight for our children's health! Water can be poisoned for private wealth! We will fight for our children's health! Water can be poisoned for private wealth! We will fight for our children's health! Shame on you! 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 Shame on you!
Oh, yeah,
I'm standing for help and for yours too. Okay, you need to go. Thank you.
We take our water seriously.
So do we.
Yes.
We take your water seriously too.
Good.
How about your water?
Sorry? I would welcome the opportunity to answer a lot of the questions and a lot of the implied questions by this recent protest after we've had the technical presentations. There's many complicated issues wrapped around oil and gas production in the state, which has been going on for 100 years. I'm quite happy to answer a lot of questions as best as I can around many of these issues. What I'd like to do is to proceed with the technical presentations, and then we will open it up to technical questions and answers, and then we will open it up to broader questions that I may or may not be able to answer depending on the question. I certainly don't want to quell protest or a vigorous discussion of the issues of the day. I think that's vital to a vibrant economy and a vibrant democracy. But I would like to do it in a respectful way where questions and answers can be taken, questions can be asked, answers can be given in a way that tries to convey understanding. So I'd like to continue with Rob Habel's technical presentation. Thank you.
Okay, so continuing on with the presentation, again, we were talking about the aquifer exemption process. And the first one is the threshold that you have to get over is the aquifer that you're looking to exempt currently being used for beneficial use. And so it not only can't be being used currently, but it won't in the future. And so if it's again hydrocarbon producing, then there's a good chance that you won't be drinking that water in the future because we already have some hydrocarbons in that. Many of you may not be aware that production in California, when you're producing oil, a lot of water comes back with the oil you're producing. Round numbers is if you produce 100 barrels of fluid, 10 of those will be oil and the rest will be water. That water is in the same formation, the same aquifer with the oil. And so that water comes back up and then is then injected back into the reservoir, mainly for enhanced oil recovery, but in some cases for disposal. So again, we have to look at what's the area that we're looking at. So we have to get supporting documentation that clearly delineates where the productive limits are of the oil field. Similar to what I showed you earlier in our volumes of the oil and gas fields, those areas can change through new technology and through continued production. So for those that want to apply that the aquifer is at a depth and location that makes the recovery of water very difficult, the data has to show clearly that it's at a location and that it's too economically difficult or it's too expensive to produce. This is kind of a trying question these days because with the continued drought in California, people are drilling deeper and deeper. So whereas, let's say 30 years ago, maybe the typical water wall depth was, but let's say it was 1,000 feet, people are going much deeper these days because of the lack of water. So the data that's provided has to be current and accurate. One of the other thresholds that you can apply for is if it's so contaminated, and that it's too expensive to treat. There are many things that are in the water associated to the oil and gas production. Some waters have high boron levels, some have high arsenic. If there's a constituent in the water that makes the water unusable for beneficial purposes because of one of these constituents, then that could be grounds to allow an aquifer exemption. Even though the total dissolved solids of the fluid could be very low, it could have so many other contaminants in it that you just can't use the water. So that would be another avenue to move forward with an aquifer exemption. The other one is that if you have the TDS of the zone in question or being proposed between 3 and 10,000, is it reasonable that this will ever be used for beneficial purposes? And the Safe Drinking Water Act, again, focuses on drinking water. The state has a little higher bar, so if it's ever going to be used for beneficial purposes, you have to provide information why, for whatever reasons, why it will not be used in the future. So once the division receives the supporting documentation, as well as the documentation that we have in-house, we'll provide it, and if we believe that the aquifer exemption is as appropriate, then we will provide a draft letter to the US EPA and forward this on to the Water Board. But you have to realize that the application for an aquifer exemption to the US EPA doesn't come from one single agency. It actually comes from the state of California. It just so happens that Division of Oil and Gas is the point of contact, but we don't work in a vacuum. So we work very closely with the State Water Board as well as the Regional Water Quality Control Boards. So once we have, if we feel the information supports it, and again, we don't have all the answers, we then forward it on to the State Water Board, who will then work with the regional boards to do their evaluation to determine if they think it's appropriate as well. And, you know, if there's reason for us to obviously sit down and discuss the data that's provided, then we'll sit down with the Water Board and the regional boards. In fact, we're meeting with them on a regular basis as it is on many different issues. So again, we're not working in a vacuum, but we're working very closely together. So the division, you know, when it's appropriate, that after it gets to the Water Board, the Water Board agrees that it is appropriate to move this forward, then there'll be a state application that will then provide some public comment before it goes to the US EPA. So we provide the comment to public on the proposed aquifer exemptions. If people have concerns based upon where the area is and the depth that we're talking about of the zone and the nature of that water, there'll be a form that they can provide comment to that. Once the public comment is complete and we address their concerns, then we forward on the application to the US EPA. If it never gets out of any of this process within the state, it never even goes to the US EPA. Again, it's a state application, so the state has to be comfortable moving forward with the aquifer exemption. So I'm going to briefly go through the State Water Resources Control Board's review criteria, and hopefully there'll be a little more detail provided by Scott. So the water boards are going to be looking at several pieces of information, or at least the criteria, in evaluating whether this aquifer that's being proposed qualifies or not. So they'll be looking at a lot of information from the US EPA in this evaluation, looking closely at what the guidelines and the regulations provided by the US EPA. There's also an EPA checklist, making sure all the data is there and it actually supports an aquifer exemption. The operators provide, the operator with the Division of State has to provide this technical demonstration that this does meet the criteria. And then there has to be an evaluation of current and future use of this aquifer. And as I mentioned before, if there's going to be a use for this water in the future, then that's a very high hurdle to get over. And again, the State Water Board is not going to be working in a vacuum. They work very closely with the Regional Water Quality Control Boards as well, who have experience working locally in the area, knowing the issues in the water quality as well. So again, once the Water Board has reviewed all the data, then there's a couple options that moves forward. Either they say this is great, it meets all the criteria that's outlined, and we'll move forward. If for some reason they don't think that it quite gets over the bar and they need some more information or clarification from the operator, they will require additional information, probably have meetings with the Division of Oil and Gas as well as the operators to discuss the supporting documentation to see if it actually does support an aquifer exemption. Or if based upon the data it's clear that the aquifer will not qualify for an aquifer exemption, then basically it won't move forward from that point forward. So the interim process, the period that we have, because we have some wells that have been identified that are injecting to zones that may require an aquifer exemption. And so the Division of Oil and Gas, the State Water Board, as Steve said, the Governor's Office, as well as EPA, have worked together to come up with a compliance plan to bring all these wells into compliance with the Safe Drinking Water Act. And basically, the cutoff date for that is February 15, 2017. So we have to look at where these wells are right now, look at all the individual issues and technical data surrounding where these wells are to make some evaluations of the zone to see if it actually does qualify for an aquifer exemption. As I mentioned, the Division of Oil and Gas has supplied a plan to the, I should say, it's not just the Division of Oil and Gas, it's actually the state has provided a plan to the US EPA. Again, the Division of Oil and Gas and the State Water Board has provided a plan to the US EPA. And the EPA has reviewed the plan and approved it with a few conditions. And basically, we now have a path forward to come into compliance with the Safe Drinking Water Act. So for those wells that are disposing into non-hydrocarbon producing zones that are not exempt with water quality of less than 3,000, basically applications will be permitted to act. These applications, we'll be looking at it, but they really can't, we're evaluating these projects to see if there's actually any way they can get an aquifer exemption. These existing wells will be able to continue to inject, but only until October 15th, 2015. So basically this October, we're going to make sure we evaluate those, and so if the operator clearly believes that those zones should be exempt, then they need to provide us information very quickly for us to move through the process, which again is the Division of Oil and Gas looking at it, the State Water Board, and EPA. Failure to obtain an aquifer exemption by October 15, 2015 result in any injection to those zones ceasing. Projects for applications that are injecting into water quality between 3,000 and 10,000 will be looked at and considered again on the information provided. Obviously, there's going to be a higher level of scrutiny for those that have a TDS close to 3,000. We're really concerned about the 3,000. That's kind of part of the federal program, and David may talk about that. We have to have a substantial and a non-substantial aquifer exemption. 3,000 is similar to the cutoff. This is above 3,000, so between 3 and 10,000, we're looking at that. All the data, of course. We're not letting any of them go through haphazardly. They're all being evaluated. But again, maybe a much closer look at those that are closer to 3,000. Enhanced oil recovery obviously is not quite as much of concern because we know there's oil there for sure, because you wouldn't be doing enhanced oil recovery. You wouldn't be spending money to make steam to inject into a zone if there was no benefit of getting any oil back out. So enhanced oil recovery means that you're actually injecting into a hydrocarbon zone where there already is oil. So this class, requires also detailed analysis. And again, the challenge is to delineate what is the extent of the hydrocarbon producing zone. And usually that's many times delineated by where the producing operations are occurring, the extent of those producing operations. And then again, those wells, the enhanced oil recovery between 3 and 10,000. Again, we're looking very closely at these, and again, more scrutiny goes to those that are close to 3,000 than to 10,000. Okay, so in the news, there has been some talk about these 11 aquifers that have historically been treated as exempt. And this goes back to issues that occurred back at the time of primacy, back in 1982 and 1983. There are 11 zones, 9 hydrocarbon producing zones, that there's been some lack of clarity on whether they're exempt or not. There's been documentation that shows it on both sides of the fence. Yes, it's exempt, no, it's not exempt. So those we're going to try and get a handle on those, because it's unclear whether they were exempt back in 82 or not. And so we're moving forward to look at these, and we'll be evaluating these between now and February of 2017. And so we're looking very closely. If they meet the criteria for an aquifer exemption, then we will solidify that. If they don't meet the criteria for an aquifer exemption, they don't qualify, then injection will have to cease into those zones. Okay, so in conclusion, basically I just want to reiterate that the Division of Oil and Gas is working very closely with the Regional Water Quality Control Boards, the state water boards, and US EPA. We're meeting on a regular basis. We work together to develop this compliance plan, and we're all in agreement that this is the most appropriate way to move forward. I'm going to finish with that. Thank you for your time. I'm now going to load the PowerPoint presentation for the State Water Board.
Thank you, Rob. Our next speaker is Scott Couch, who is the section chief for the groundwater protection of the State Water Board.
Thank you, Steve. As Steve said, I'm the section chief for groundwater protection at the State Water Board. I wanted to give a little bit of context before I go through my presentation. I have a short presentation here, but I wanted to appreciate the sentiments of the folks that were in here protesting and saying, you know, you guys are the regulators. You are supposed to be regulating this activity and protecting the groundwater. And that is, you know, the title that I have. The State Water Board does not have a UIC program. We were brought into this activity, and I just wanted to say that some of the news stories that are out there, I think we could probably do a better job of showing what it is that we're doing here, and maybe with some more mapping or graphics, but we could do a better job showing that. I wanted to say the vast majority of these exemptions that we're looking at, these exemption requests, are on the boundaries of existing oil fields. So back in 1973-74, they basically took a pencil and drew a line around the producing oil wells there. Obviously the technology's changed over time, and so those oil fields have expanded. And so the exemption, the majority of these exemption requests that we're even entertaining or even looking at are for those areas where the current oil field or the oil fields from 1973 and 74 have expanded. And so I just wanted to try to put that into context. It seems like the news stories are showing that this is, you know, these wells are spread out over the state, and this is a problem of contamination of great proportion. So I want to assure you that the water boards are not interested in having aquifers contaminated. I'm not interested in having aquifers contaminated, and so I'll go through what is a short presentation here. I'm sure there'll be several questions afterward, but sort of our process of what we're doing here. So I'm going to talk about the exemption application and what the water boards are going to do with their review when it comes to us, and what the possible conclusions that we might have after we look at this, the material that's been submitted. So an aquifer exemption is going to be submitted to the water board from Dogger. They are going to have already looked at this exemption application. They're already going to have reviewed it and verified that it meets the criteria for an aquifer exemption under the Code of Federal Regulations for underground sources of drinking water. And they're going to provide the water board with their recommendation as to whether or not this zone, this area meets the criteria under the underground sources of drinking water. At that point in time, the water board is going to look at the application with Dogger's recommendation, and we're going to see if we have any issues with it and what our recommendation would be. Now, as I said, Dogger's going to be saying whether this meets the criteria for underground sources of drinking water. They're going to identify those zones that are classified as underground sources of drinking water. They're going to identify those zones that are classified as exempted aquifers under this Code of Federal Regulations, 40 CFR 144.7. We are also going to look at that criteria and see if we concur that it meets that criteria. We're also going to look at the EPA guidance document, which David will talk about some in a minute, and the state UIC program provisions to see if it complies with those, and the EPA aquifer exemption checklist. But as I said, Dogger would have already looked at these things. We are also going to look at those and verify that we concur with what they are recommending. So once that's been done, we're going to take it to raise the bar, so to speak. There are criteria under the Code of Federal Regulations that look at underground sources of drinking water, that look at aquifer exemption criteria. But the state of California, as directed by the governor's office, when we have met with them and Dogger, they would like us to look at the Port of Cologne, the water code, beneficial uses of water, and other criteria to make sure that waters of the state are not affected by any discharge from an injection well, a waste disposal, or a discharge from an injection well or an injection project. So what we're going to be looking at from the operator is a technical demonstration that any waste that is injected, any water that is injected, is going to be contained in that exempted portion of the aquifer. Rob went over some of this and showed the surface representation of where that is. He also went over that there's a vertical component to that. There may be areas within that horizontal area that are exempted and zones that are not exempted in there. So we're going to be looking at a technical demonstration by the operator showing that here's what the injection project is, and here is a demonstration that shows that we believe that anything is injected will stay within that particular exempted area. We're going to also look at current and future beneficial uses of groundwater. Now the 40 CFR, the Code of Federal Regulations, talks about current and future underground sources of drinking water, so that it could not now or in the future serve as a source of drinking water. We're going to be looking at, could it now or in the future be a beneficial use of water? We're also going to look at elements of the Regional Water Quality Control Board's basin plan. So just as context, the State Water Board in Sacramento, where I work, there are also 9 regional water quality control boards that Rob mentioned. They have expertise in their particular region. They're set up as on a watershed type basis. Where the oil production activity is mainly going on is in the Central Coast region, the LA Basin, the LA region, and also the Central Valley region. So those are 3 of the 9 regional boards that are mainly affected by this. They each have a regional water quality control plan, which is called a basin plan, and it lists beneficial uses of water in that basin plan. And so those are the types of things we're going to look at. Are there current beneficial uses of water, or the potential future beneficial uses of water, which is a much higher bar than does it currently or could in the future serve as underground source of drinking water. So we looked at what are the possible conclusions that we could come up with after we review the materials submitted by the operator or the group of operators. It's going to go to Rob in particular at Dogger. They're going to look at it, do a review, they're going to send it to us. We're going to look at it, confirm what it is that they looked at, confirm the review that they did. We're going to put this additional scrutiny on it. We're going to talk to the regional boards, make sure that they concur with us. They've looked at their basin plan, they've looked at beneficial uses, and we've determined that it could not affect waters of the state or other beneficial uses, you know, for that injection project. So if we make that determination, these are three possibilities that we came up with. It may not be everything, but this is what we think. So one is the possibility that all that material and their supporting data, and we concur with the exemption request. We will send a letter to the state oil and gas supervisor, to Steve at Dogger, and we will copy the operator or the operators and say, okay, we concur with your exemption request. And at that point, it would be an exemption request from the state of California to US EPA. And David will talk about the US EPA process in a bit. The second possibility is that the water board concurs with a portion of the aquifer exemption. So let's say you submitted for a large area, large oil field, expanding the field, and we looked at it and we said, well, over here, we think it could not affect beneficial uses of water, and we would be okay with exempting that portion of the aquifer. But over here on the other side, we do not concur, and we think that it could possibly affect beneficial uses of water, and so we don't concur with that portion of the aquifer exemption. If that's the case, we would send a letter saying that in fact we concurred with the one area, and we would specify those areas. And we may either say, well, we do not concur with the other area of the request, or we may say we would need additional information to be able to concur with that section. The third possibility is that we say, well, we don't think that it meets the criteria. Either we say, well, we don't agree with the determination, we don't concur with Dogger's determination that it would meet an exemption under the underground sources of drinking water, or we could say it may meet that criteria for an exemption under the Code of Federal Regulations, but it does not meet the water board's criteria or for beneficial uses of water, and we think that an injection could potentially impact waters of the state, and so we don't concur with that request. And we would also put that in writing and send a letter to Dogger and the operator. So those are the three possibilities that we have considered. I'm sure there might be others, but they're unique situations. So that's really that's my presentation. So as Rob said, it goes through the criteria that we have. Applications will come from the operators into Dogger. They will take a look at it. They will send it to the water board. We'll see if we concur. We'll look at beneficial uses. If we do concur with that, an aquifer exemption request will be submitted to US EPA. And so David will talk a bit about what it is that they're looking for.
How many tons of water does it take to extract the oil?
Let's take questions. You hang on to that question for just a little bit longer. Okay, for the last technical presentation, I'd like to introduce David Albright. David is the head of this Drinking Water Protection Program at US EPA Region 9.
Good afternoon, everyone. My name is David Albright, and I'm the manager of the Drinking Water Protection Section at EPA. EPA has 10 regions, and I'm in the San Francisco office. We oversee environmental programs in California, Arizona, Nevada, Hawaii, and the Outer Pacific Islands. So what we'll be talking about today are key principles of the Safe Drinking Water Act. That's the federal statute that we're operating under, the Underground Injection Control Program, of course. Some background on aquifer exemptions, roles and responsibilities of EPA and the other agencies, EPA's review of aquifer exemption requests. I'll talk a little bit about consistency and predictability in the aquifer exemption review process, something that EPA has put some information out on last summer out of our headquarters office. And then finally, the basis for exemption and EPA's assessment. So as I noted, we are talking about the Safe Drinking Water Act. This is a federal statute, and both the Act and the Underground Injection Control Program are designed to prevent endangerment of underground sources of drinking water. That's sort of a term of art, underground sources of drinking water, that's in the EPA regulations. It's defined at 40 CFR 144.3. It basically means it's an aquifer which supplies any public water system or which contains a sufficient quantity of water to supply a system, and that currently either supplies water for human consumption or contains fewer than 10,000 milligrams per liter of total dissolved solids, and which is not an exempted aquifer. So it's basically an aquifer that has a quantity that can supply a public water system or is supplying water for human consumption, and is a quality only based on TDS of less than 10,000 parts per million, and it is not exempted. So once an aquifer is exempted, it is not considered an underground source of drinking water. All USDWs are required to be protected by the USC program. So just a little background on aquifer exemptions, because I know it can be a difficult concept to understand. Aquifer exemptions allow injection into an aquifer which would otherwise be prohibited by the UIC program. And these exemptions have primarily been used to allow for mineral, hydrocarbon, or geothermal energy production. All aquifer exemptions require EPA approval. So even in a case where a state has primacy for the UIC program, such as California has for the Class 2 UIC program, it is still EPA who has final approval authority for approving or denying an aquifer exemption request. In approving aquifer exemptions, EPA makes a determination that the proposed aquifer exemption area is not currently being used as a source of drinking water and will not be used as a source in the future. It's sort of it's a two-pronged test, and I know Rob and Scott talked a little bit about that. I'll elaborate. And the last point I wanted to make on just background related to aquifer exemptions is there is additional scrutiny, I would say, over the last 3 to 5 years on EPA's rationale and the consistency that's being applied to aquifer exemption requests and approvals across the country. So let me talk about roles and responsibilities in the aquifer exemption process. First, states or tribes, because tribes can have primacy as well for the UIC program. States or tribes with primacy can identify, after notice and opportunity for a public hearing, additional aquifers for exemption. Typically, the way this works is injection well operators initiate the process, they collect the data, and submit the request for an aquifer exemption to the state. The state then, or tribe, then reviews the aquifer exemption request, conducts analyses, and determines whether to submit to EPA. So this is a really important point for everyone to understand, which is that EPA has regulatory criteria, and I'll talk a little more about the regulatory criteria, but the bar that needs to get over is at the state level first. The state has to determine that not only the request meets EPA criteria, but that the state is willing to put that aquifer exemption request forward to EPA, that the state has determined that the best use of that aquifer, if you will, is for the purpose of injection, as opposed to other potential purposes. So what is EPA's role? The region in this case, EPA Region 9, in my regional office, evaluates the application and responds to the state. Where EPA has direct implementation authority, where we're directly implementing the program, the operators deal directly with us, they submit the request to us, but in this case, especially with Class 2 UIC, it's the state which has primacy, and so the state will be the initial filter for what is coming to EPA for consideration as an aquifer exemption. The final determination of a request is documented by EPA in a statement of basis, and that statement of basis would explain the factual, technical, and legal bases for our determination to either approve or deny the aquifer exemption request. Our headquarters office back in Washington, they offer support to the different EPA regions who are considering these aquifer exemption requests put forward by states and tribes, in particular for substantial or complex requests, and also to promote national consistency. So I want to talk briefly about the federal regulations. There are really two sections of the federal regulations that address evaluation and review of aquifer exemption requests by EPA. The first is at 144.7. This section of the regulations allows UIC program directors to identify aquifers or portions of aquifers that are exempt from definition as a USDW. It describes how such exempted areas of aquifers will be delineated, and it lays out some of the procedural requirements for aquifer exemption requests. So this basically is providing authority to the UIC program director. In this case, that would be with the Division of Oil and Gas, who's the UIC program director, to identify aquifers potentially exempt. 146.4 is the portion of the regulations that then identifies the criteria that are used to determine whether an aquifer exemption request can be approved by EPA. So the regulations at 146.4, I know this is a bit of review, but I think it's important to see it in context. There's A, B, and C under 146.4. And criterion A says that it does not currently serve as a source of drinking water. So that's the first step. An aquifer that currently serves as a source of drinking water cannot be exempted. So the state needs to determine first, for any request that comes before them, the aquifer is not currently serving as a source of drinking water. But that's not enough. It needs to meet one of the additional two criteria, either in B or in C. So under criterion B, there are four sub-criteria. Rob went through them, but basically, this is the portion of the regulations that says this aquifer, not only is it not serving as a current source of drinking water, but it will not serve as a source in the future for the following reason. And there are four potential reasons that are provided in the regulations. First, it could be mineral or hydrocarbon producing. The second is that it's situated at a depth or location which makes recovery of water for drinking water purposes economically or technologically impracticable. Third is that it is so contaminated, and by that we're talking about natural contamination of the aquifer. It's so contaminated that it would be economically or technologically impractical to render that water fit for human consumption. And then the fourth sub-criteria under B actually doesn't apply to Class 2, but I wanted to put the entire regulatory language up there. It has to do with Class 3 injection, which is for solution mining. So those are the sub-criteria under B. So it has to be criterion at A, and either one of those under B or the criterion at C. And that criterion is that the total dissolved solids content of the groundwater is more than 3,000 and less than 10,000 parts per million TDS. and it is not reasonably expected to supply a public water system. So it's that range of quality of the aquifer between 3 and 10,000, not what the state calls freshwater, but a lower quality between 3 and 10,000, still an underground source of drinking water by EPA's regulations. But it's determined that it's not reasonably expected to supply that aquifer, the water in that aquifer is not reasonably expected to supply a public water system. And I'll get into a little bit, a few of the considerations that we look at under that criterion. So EPA has put out some guidance about aquifer exemptions. Guidance 34 is one of the documents that EPA developed. This is a very old guidance document, but we have not rescinded it. It actually was a guidance that was developed to talk about program revisions for the UIC program. Once states or tribes get primacy, how you revise the program, and certain types of aquifer exemptions are considered program revisions and therefore were discussed in Guidance 34. What Guidance 34 includes is some guidelines for reviewing aquifer exemption requests. I know Scott referred to this as one of the elements that the state would be looking at when they do their analysis, and how to apply the regulatory criteria that I just went over, which is at 146.4. It describes the concept of substantial and non-substantial program revisions and addresses review and approval of non-substantial revisions, which are the responsibility of the region. A substantial program revision would be handled by our headquarters office, but all non-substantial program revisions would be, could be approved in the regional office in San Francisco. The guidance also discusses the evaluation criteria to demonstrate that an aquifer is not a current source of drinking water, including surveys of the proposed exempted area to identify any wells which tap into that proposed area. It's sort of a reasonable thing that obviously would need to be done to look for water supply wells that might be tapping that aquifer to determine whether it is a current source. It also recommends evaluating at least a mile, quarter mile rather, area around the proposed exemption boundary to determine if the exempted area currently serves as a source of drinking water. That's really considered kind of a minimum standard, but that is in Guidance 34 that was that EPA issued in the 1980s. I want to talk a little bit about timing for some of the review. So the UIC regulations allow for aquifer exemptions to be submitted to EPA for determination either at the time of primacy. So when a state first gets primacy for the UIC program, that is an opportunity to seek aquifer exemptions. The state did that with their primacy application in the early 1980s, and EPA approved a large number of aquifer exemptions at that time of primacy. And then subsequent to program approval, which is where we are now, after public notice and opportunity for a public hearing, UIC program directors can submit additional requests for aquifer exemptions. Upon receipt of an aquifer exemption request, EPA compiles and reviews the information, conducts analysis, and may seek additional information from the state or from other sources. Our hope certainly is that any aquifer exemption requests that come from the state are very well documented with data, make the case, and will be relatively easy for EPA to evaluate and make a determination under the regulations. Once a determination is made, EPA then documents its evaluation and analysis of the information, and our determination is to either approve or deny the aquifer exemption, and we document that in a statement of basis. So just one little distinction that I wanted to point out amongst the aquifer exemptions, depending upon which criteria are applied in requesting those exemptions. The designation of an aquifer that's being exempted under the criteria A and one of the B criteria is not final until it has been approved by EPA as either a substantial or a non-substantial program revision. However, aquifer exemption requests that come in under A, obviously, because it has to be demonstrated to not be a current source of drinking water, but then C, which is the quality is between 3 and 10,000 parts per million, or milligrams per liter, rather, total dissolved solids, and it is not reasonably expected to supply a public water system. For those requests, that are submitted under 146.4A and C may become final if the state director submits the request in writing to EPA, so a formal submittal to EPA, and EPA has not disapproved the request within 45 days of submittal by the state. So for aquifer exemption requests, any that come in under criteria A and C, there's really a 45-day clock that EPA has to make a determination on those requests. And if EPA has not acted, then they become final. So last summer, our headquarters office, the Office of Water, Office of Groundwater and Drinking Water, put out a letter to all of the EPA regions and a checklist, a policy memorandum that talked about aquifer exemptions. It was really one of the first documents that was written by EPA about aquifer exemptions since Guidance 34 in the early 80s. So I wanted to talk about that a little bit. So the policy memorandum, which was issued by Peter Gravatt, who's the director of our Office of Groundwater and Drinking Water, a few of the points, key points from that memo. One was it strives for consistency and predictability in the aquifer exemption review process. So as I noted, there are 10 EPA regions. Each region is looking at aquifer exemption requests from states and tribes in their region. So our headquarters office is definitely looking to try to ensure that the greatest amount of consistency as there can be is made as each region evaluates aquifer exemption requests and makes determinations. The memo introduced a checklist that we recommend for use when evaluating aquifer exemption requests. The checklist goes through each of the regulatory criteria and talks about the type of information that would be necessary to provide as part of an aquifer exemption request. It highlights some factors that make certain aquifer exemption requests more complex than others. In particular, if there are nearby drinking water wells to an aquifer that is being proposed for exemption, that certainly makes the situation more complex than a situation where you don't have, just as an example, a drinking water well for 15, 20 miles. That may be an easier case to look at. It suggests early consultation between EPA regions and states to discuss key issues. We're certainly having a lot of discussions with the state about these issues, so I definitely think we're implementing that piece of the memorandum. And finally, it articulates EPA's view that an area proposed for exemption currently serves as a source of drinking water if wells that are currently in existence draw water from the exempted area at present or in the future. So that's a somewhat difficult concept, but our notion of what is current use of the aquifer is not just that there's a drinking water well or a water supply well that's tapping into that aquifer, but there could be wells that are situated outside the boundaries of that aquifer that in their lifetime will draw water that is in the aquifer at the time that you're considering to exempt it. So that we would also consider that current use of that aquifer. Regarding the checklist that was attached to EPA's policy memorandum, it's important to note that it's not a one-size-fits-all, and it really covers all the different types of exemptions that there might be. There are a number of exemptions under not just Class 2 UIC program, but Class 3, Class 1, Class 6, which is the carbon sequestration injection well. So it's really a document that's supposed to serve all kinds of different purposes and isn't just a one-size-fits-all. The checklist facilitates discussions between EPA regions and applicants or the state and helps to manage expectations about the process. It also is helpful to EPA as we document our own analysis and our findings in the statement of basis to evaluate that information in the checklist. So I'm going to close with two more slides to really just bring home the point. It's about current use and it's about future use. And so the current source assessment, really the question, what constitutes an aquifer that currently serves as a source of drinking water? First, it must be determined whether any drinking water well, either public or private, either exists within the proposed exempted boundary or is beyond the exemption boundary, but may draw water either currently or in the future from the proposed aquifer. And that's essentially the concept I was talking about a moment ago, about looking for water supply wells that may be drawing from this aquifer. If there are drinking water wells within or in close proximity to the proposed exempted area, then obviously further analysis would be required to look at the specifics of those wells and the hydrogeology and other technical factors as part of the current source assessment. If any public or private drinking water wells are capturing or producing, or will capture or produce over the lifetime of the well, drinking water from the proposed exempted area, then the aquifer currently serves as a source of drinking water and could not be exempted. With respect to the future use assessment, what I've done here is just listed some of the factors. Obviously, the criteria under 146.4b are factors that you would look at, things such as whether it's mineral, hydrocarbon, or geothermal producing. But as you get into the other criteria about the economic feasibility and technologic practicability of cleaning up the aquifer or drawing from that aquifer for drinking water purposes, or when you look at the criteria under 146.4c, where you're talking about an aquifer that's not quite as fresh, but trying to make a determination as to whether it will reasonably be expected to supply water for a public water system. These are some of the factors that ought to be considered. Factors such as the likelihood that water in the exempted area would need to be used as a drinking water source, the remoteness of the location, the population dynamics in that area, the availability of alternative water supplies to satisfy future water needs, looking into population projections and growth for that particular area, looking at future demand in the area, looking at alternative water supplies in the area, just really looking at all of the different factors about whether this aquifer may be a source, may need to be relied on as a source for drinking water in the future, even though it's not currently a source of drinking water. It's also important to look at the available treatment or drilling technologies. As one of the presenters was talking about, obviously people are drilling deeper and deeper for water, so it's important to consider that as part of the future use assessment. And then lastly, the cost of obtaining drinking water from deeper aquifers. So it's all part of the calculus that needs to be evaluated as part of that future source assessment. Okay, thanks for listening.
Topics. Yes.
Did Mr. Couch say that the state has no UIC control program?
No, the state has a UIC control program. That back in 1982, when the state applied for the responsibility to manage the UIC program, which gets delegated by the US Environmental Protection Agency, the Division of Oil and Gas was the state agency that applied for and received what's called primacy. So the State Water Board is a partner with the Division of Oil and Gas, but technically the Division of Oil and Gas is the responsible party within the state for the management of the underground injection control program.
So a follow-up question, what type of resources does Dogger have to monitor and enforce the regulations that it's implemented for that program?
Well, the UIC program has been a program inside of the division since the early 80s. And there's, when you ask what kind of resources, there's a number of staff. I don't remember exactly the number of staff. There's probably 50 people involved with the, that's probably too many, probably 35 involved with the underground injection control program. The division has about 220 employees. So it might be a little more. I could get you the answer exactly, but I don't know the answer just off the top of my head. Yes?
Are you dependent on industry science to make these decisions? Or do you do
The
that
question is, are we
independently?
dependent on industry science to make these decisions? We are requesting information from the industry, but we are not dependent on them to make a decision about the suitability for an aquifer to be exempted or not.
Where else would you get your technical data from then?
Well, the technical data come from Dogger's own data and the Water Board's own data and data from local municipalities and so forth.
Okay, so you have independent scientists in the field verifying these
Yeah.
facts? Okay.
Yes?
Where will the EPA be listing applicants for the exemptions so that community members or people with neighboring properties will know there's someone attempting to do that?
I don't think it will be up to the EPA. It'll actually be up to the Division of Oil and Gas. And what we plan to have is on our website is, if you've visited our website lately, you will see a considerable amount of information about underground injection control. And there will be some information about what aquifer exemptions have been applied for and what their status is. As part of the process to exempt an aquifer from the Safe Drinking Water Act, there's a requirement for a public comment period. So those will be readily seen from the website.
From the back, if the audience could raise its hands when you have a question so we can get a microphone to you.
Yeah, hi, sorry, I think you said that Dogger and the water board's own technical data will be used in assessing the aquifer exemptions. Currently, Dogger don't even actually know where all the illegal injection wells are. So your own data is pretty deficient, isn't it?
Yeah, our data aren't the quality that we'd like. That's why we asked for additional information from industry. Of course, there are criteria about where beneficial use water wells are that aren't the division's responsibility, but the responsibility of the water board. So that comes into play as a very initial screen on whether or not an aquifer is even going to be considered for exemption.
But ultimately, oversight is conducted by you agrees sufficient data.
I'm sorry, I didn't hear you.
Ultimately, oversight is dependent on what you just agreed is sufficient data.
There'll be plenty of oversight. I'm not worried about that, yes.
I'm Steve Damon Nagami with Natural Resources Defense Council. I have two questions. First, in terms of the public comment process, it sounded like Dogger is going to have a public comment period. Is there a separate public comment review period that the water board is going to hold for when they do their evaluation?
No, the application comes from the state, so it's a unified state decision. So once the state has decided that what their recommendation is, then it's opened up for public comment before it goes to EPA.
Okay, and then any comments on water board decision making or data should go in during the one public comment period, is that right?
Yes.
Okay. My second question is regarding the compliance plan and the interim process. What's the legal basis for allowing this 2-year period to come into compliance? I mean, we've heard statements that some wells are injecting into zones that may be requiring exemptions, which seems to imply that these injections are illegal at this time. So what's the legal basis for having a compliance period and plan rather than basically shutting down all of these illegal wells immediately and trying to do the science to figure out where these exemptions should be placed in the future?
So I'm not a lawyer, so I'm not going to talk about the legal basis. What I can tell you is what the thinking that went into this. First of all, as has been widely reported, there is considerable uncertainty about which aquifers are exempted and which aren't. And that stems from what happened in the early 1980s and the Memorandum of Understanding. So we have a situation where we aren't completely sure that the wells are illegal or not. And then secondly, from the point of view of public health and safety, we already know that of the roughly 2,500 wells that are out of compliance with the Safe Drinking Water Act, we know that over 2,000 of those are involved in injection activities inside hydrocarbon reservoirs. That is, the water that comes out of those aquifers or is then returned to those aquifers is mixed with oil. And so therefore, the potential for, first of all, those aquifers have a very, very high likelihood of being exempted because they are extensions of existing oil fields. And so I know that it's often repeated in the press that those injection wells are injecting into drinking water. That's false. It's water that might be less than 10,000 TDS, but it has abundant oil in it. There are a bit over 500 wells which are injecting into aquifers that are not hydrocarbon bearing. As far as we know, it turns out that as we do more research, we find out that some of those aquifers are in fact hydrocarbon bearing or were once hydrocarbon bearing, and therefore have some oil in them. A lot of those aquifers, most of those aquifers lie between 3,000 and 10,000 TDS and aren't currently being used for beneficial use. There are about 170 wells. It turns out that's the original number. A lot of those have been abandoned and plugged and so forth, and those have been of highest concern. And we are closing those wells as we find wells that are proximal to, that's within a mile radius of a beneficial use well. So we think that, we feel that this is an approach that the state and EPA has agreed to. We think it's a prudent approach given the uncertainty of aquifers which have been exempted, and the fact that there's many competing needs, and so we first focus on public health and safety, and we're closing wells as we see evidence that there might be, out of a extreme caution, there might be the potential for degradation of the aquifer. So far in the limited testing, albeit limited testing the water board has done, they haven't found any. And that's where we're starting. So there's a lot of issues wrapped around the decision, but most importantly, the vast preponderance of wells are involved in aquifers that are exceedingly unlikely ever to be used for drinking water, because they contain substantial amounts of hydrocarbon.
Tom Williams here. Couple things, easy ones first. Slides, the presentations today, will they be on?
I think they're already up on our website. Yeah, they'll be up.
Yeah. Okay. The basic element seems to be the mentioning of economically and technologically infeasible, economic and technical impracticality, and then in the EPA one, cannot now and will not reasonably be expected. How would you outline the process that Dogger goes through with the operators to establish reasonable, other than can they afford it or can they not afford it? Because you have the impractical. Impractical to me is they can't afford it. So how do the technology, I believe, is there. It's just a matter, it's very expensive. So what is the practical reasons for either granting or not granting a UIC permit for injection for disposal?
Well, that's a matter of judgment, right?
Yeah.
And probably you might judge things differently than others might judge.
But are the parameters and the criteria?
Well, they're not concrete because there's many different factors that go into it, right? It's where is it located, number one. What is the naturally occurring contaminant that might make it very expensive for it to? What's the depth of the aquifer? What else is in it, and so on and so forth. So you're asking a question. You're asking for certainty around something for which there are enormous ranges in each of the criteria that are used.
But there's a final decision. Yes, they get the permit, no, they don't.
Well, the final decision rests with the US EPA. And David may want to add more to what I'm saying, but the final decision rests with the US EPA, Region 9, if it's an aquifer of greater than 3,000 TDS. If it's an aquifer of less than 3,000 TDS, it has to go back to headquarters for review.
yes. My name is Lou Noble. And so how many tons of water will it take to extract the oil?
Well, I'm not quite sure what your question is. The vast majority of oil that's produced in the state, the oil that's produced doesn't take any water. It produces around somewhere between 13, 14, or 15 barrels of water. So, in fact, as I said, for the vast preponderance of production of oil in the state, most doesn't require water. There is some cyclic steaming for which water is used, and that's not a large amount of water. And if you're addressing hydraulic fracturing, the year for which we have data, we know that about 325 acre-feet of water was used in hydraulic fracturing operations last year. Of that, roughly 2/3 of that was from cleaned up produced water. And so the amount of water used for hydraulic fracturing hydraulic fracturing activities that you would consider fresh water is around 100 acre-feet. So let me put that in context. The golf courses in this area use in the summertime probably over an acre-foot, some up to 3 acre-feet of water per day. So I hope that puts that in some context for you. Each golf course, that is, would use that amount of water.
Where is it contaminated water?
Sorry?
Where is it contaminated water? Is it reusable or?
Some of it's reusable. I mean, you mean the produced water that comes out of the oil wells of California?
Mm-hmm.
So over 2/3 of it is injected back into the formation from which it came. So in other words, when we produce water from an aquifer that contains hydrocarbons, 2/3 of that water goes back down into that same aquifer for a variety of reasons. One is pressure maintenance, one is to prevent subsidence, another is to move oil towards a producing well, so-called water flood. And then some of it, a minority of it, is cleaned up for productive and beneficial uses, agriculture and so forth. And then some of that remainder that's not either re-injected into hydrocarbon-bearing zones or clean is put into other disposal wells, some of which may have been aquifers that were previously used for hydrocarbon. So it's re-injected into the subsurface.
Any other alternatives?
Well, there's a tremendous amount of interest in cleaning up this water and using more of it for beneficial use. And I think we will see that in the future. We'll see more of it. We know that Chevron, California Resources, forgetting somebody, Freeport-McMoRan already provide water that's produced water that comes out with their oil and gas operations and is cleaned up sufficiently so that it can be used for beneficial uses. In some cases, that's a fairly large volume of water, up to 25,000 acre-feet.
John Newell, Clean Water Action. I appreciate the opportunity to learn and ask questions here. In the first presentation on the interim process slide, it indicated that most of the wells injecting into these non-exempt zones will need to show that they're hydrocarbon producing zones or, quote, have a strong potential to be hydrocarbon producing. Can you explain the difference between the two of those? And if I have this right, how strong potential would meet the regulatory criteria?
Right, so the regulation requires that it's either hydrocarbon producing, so that's pretty clear. But then whether it has a strong potential to be hydrocarbon producing usually relies on exploratory drilling that's done by the industry to look for new sources of hydrocarbons. And so therefore there's evidence, there would be strong evidence in the cores and the well logs that would indicate potentially economic amounts of hydrocarbons. So that's the difference.
And you can still get an exemption for that, for strong potential?
You potentially could, if other criteria are met. That's not the only criteria.
Right.
Right. You potentially could.
But it's strong potential in 146.4.
I'm sorry?
So a strong potential considered a hydrocarbon zone as according to the regulations.
Yeah. David, you want to answer that? Or something?
Sure. So when you look at the criteria 146.4, it talks about an aquifer being mineral, hydrocarbon, or geothermal energy producing. So obviously that would be hydrocarbon producing, the first one that you mentioned. Or can be demonstrated by a permit applicant as part of a permit application for a class 2 operation to contain minerals or hydrocarbons that, considering their quantity and location, are expected to be commercially producible. So that's the potential producibility of the hydrocarbon that is part of 146.4.
Yes, I had a question over here.
Yes.
In the last presentation from EPA, and also alluded to the State Water Board, had to do with some of the future beneficial uses of water, taking into account factors as population growth projections, future demand in the area, alternative water supplies, economic viability. So I guess my question would be to both agencies, have you outlined or provided specific guidance as to how to make these kinds of determinations, since they're fairly subjective?
Well, as I said, I think earlier, do anyone want to comment on that? I mean,
Well, if I'm not mistaken, the criteria that you were listing there were for the EPA underground sources of drinking water. But speaking to the beneficial use of water and future, that is a higher bar than present or future underground sources of drinking water. So we're going to be looking at, agricultural uses, industrial uses, domestic uses, other things. And you're right, it's a subjective decision. It's not going to be a number or a criteria that we're going to be able to list out for you and say, here's if you meet this exactly, you'll be eligible for this exemption request. Much of it is due to your location and the availability of water. So you look like you have a follow-up. So
yeah, I guess the question is, if you're the operator and you're submitting an application for exemption and you're trying to address these criteria, which are reasonably subjective, how are they supposed to assess this in filing their application, or do they have to wait until the state reviews it, comes up with some criteria, and then respond to it?
So we are currently working on a guidance document. The February 6th letter from both Dogger and the State Water Board to US EPA lays out the criteria that we have that we are going to follow here. We are currently working with Dogger on a guidance document that takes the elements that are in the attachments to that letter, and we're going to try to add more specificity to it. But again, it's not going to be a particular number for each beneficial use, and if you meet that, then you'll cross the finish line. It's going to be subjective to where you are and what the availability of water is and that kind of thing. I mean, it depends on your location a lot.
I think also, as a partial answer to your question, the operators are going to submit information to the state that makes the case. And so they have to make as best a case as they can. And that's where it starts. And then the state gets to review that, possibly ask for additional data, possibly take a number of different actions that could be taken. But the operator, the initial information that is needed, there has to be an interest in making this aquifer exempted in the first place. And the operators who are presumably the ones who would be interested in this have to make the best case they can. So that's where it starts. Whether that's a good enough case or not, then is up to the State Water Board and the Division of Oil and Gas in consultation with the Governor's Office.
Hi, I heard you say that a lot of the illegal wells were in compromised areas. These weren't going to be, this was quality water anyway. But I'm just wondering if you could tell me what an illegal well actually is. I know in the city of Long Beach, I need a permit to build a garage where it's illegal. Even if it looks pretty good when I'm done, I needed that permit. In every state in the union, you have to have prior permission to drive a car, have driver's license proving auto insurance. So what are people supposed to do and with what entity before they just go out and drill a well?
Right, that's a good question. So these are wells that have been permitted by the Division of Oil and Gas. In some cases, these wells have been permitted decades ago. In some cases, they've been permitted before the Safe Drinking Water Act was enacted. And so these are wells that have been permitted to be drilled for a specific purpose. And they are currently out of compliance with the Safe Drinking Water Act and the agreement that the state has with the US EPA for the boundaries of aquifers which were exempted in the primacy agreement. So that's what that means.
Are any of these being drilled newly, or are these just very, very old? Or is somebody going out like within the last 30 days or 12 months?
No one's gone out. No one's gone out recently and drilled any of these wells. We've put a hold on UIC wells, those are now being reviewed in division in Sacramento headquarters to see that they're in compliance with the Safe Drinking Water Act. So they're getting much closer scrutiny. A lot of this work used to be done in our district offices, so they're getting much closer scrutiny. There are wells that can be legally permitted. They're in an underground injection control project. That project has been approved. It's in an approved exempt aquifer and so forth. So that's still possible. It's just that, as I think you heard Rob Habel say earlier on, a lot of the places where these wells exist are in areas that are expansions of existing oil fields that have been in production for a long time. And some of the reasons that they were permitted was confusion around the rules of the game and confusion around which aquifers were exempted and which weren't. And there was for a long time, and these are things that have gone on for a long period of time, long before I arrived on the scene last June, where if an aquifer had hydrocarbons in it, it was automatically exempt. Now that turns out not to be true, but those are that was some of the belief structure wound into the permitting of some of these wells.
Do permits expire? My driver's license expires and I must go prove my vision is good and I have auto insurance every few years.
If a well is active and it's being used for the purpose for which it was permitted, it does not, the permit does not expire. If it changes its use or it injects fluids of a different composition and so forth, then the division has to be notified, and there's the opportunity to re-permit re-permit the well. So in fact, to change its use, say it's being used as an oil producer and it wants to become an injector of fluids, that would have to be re-permitted.
A question. Earlier, Mr. Couch mentioned that there was going to be review at both the regional level and the state level as far as these applications once they leave Docker. Is that review going to be concurrent or consecutive, especially with the new impending deadlines for submittal?
Well, it depends on the region. As I said, we have the Central Coast region and the Los Angeles region and the Central Valley region. So it's going to be concurrent with Dogger. we have timelines that we have set out, and there are deadlines that we have to meet. So the clock for the State Water Board to do the review doesn't begin until it's submitted to us from Dogger. Now, they may submit something to us, prior to that, so we can get an idea of what's coming, or there may be some technical information that we meet with them and we talk about, or the operator may want to come and make a presentation about what they're trying to do. So we're certainly meeting with them, but as far as, when does the clock start for our review, it's when Dogger says, well, they're okay with it, here's our recommendation, and they submit it to the Water Board.
I guess my question is that document disseminated to regional and state water board at the same time? Or does it have to go through, let's say, the regional water quality control board for review and then on to the state?
No, it would be, again, it could depend a little bit, but it would be concurrent. It doesn't go through the regional board and then come to the state board. We look to the regional boards to provide additional technical expertise because they're more familiar generally in their area and the types of things that are going on in their region than the state board might be.
Other questions?
Hello? Yes, I was wondering, speaking strictly about the water that's used for the well stimulation process.
Sure.
You said a large portion of that is actually produced water that comes out of current producing wells. Speaking about the portion that's actually fresh water that's used to stimulate a well, and then it actually becomes produced water when it comes back out. Is there any agency that's regulating or monitoring the disposal, or just tracking that, or seeing how the water is ultimately disposed of?
Yeah, it's a class 2 fluid, so it has to go, if it's going to be disposed of in a disposal well, it has to be back into a class 2 well. And that's the division's responsibility.
So that would lead me to my follow-up. You mentioned earlier there's about 35 people that monitor the underground injection control. I guess
That's a rough estimate.
Well,
it
yeah,
could be more.
rough estimate,
Yeah.
yes. Well, we can just use that number for the discussion. But I was wondering, how many people you actually have that actually go to the sites and make sure that this is happening
Right.
correctly. And I mean, because approximately, even if it was 50 people for the entire state, it doesn't seem like enough to actually control the behavior of people who just don't want to follow the law.
Sure. So those are two different questions in my mind. When you ask what are the number of people focused on UIC, we're really talking about the execution of the program. When we're talking about our regulators out in the field, how often do our regulators get out in the field? What do they do when they're there? They're not stovepiped into, I only do UIC, I only do environmental testing, I only do this or that. So they're in the field, we have inspectors in the field every day, they're all over the place. I could talk about the number of inspections we do, I don't have those numbers off the top of my head, and they're different for different districts. We do change what we focus on from time to time, depending on what's going on in the district and so forth. But there would be many more staff out in the field looking for compliance issues, checking up on things than the 50 that I just talked about. Considerably more. Yes?
Has the outlaw of fresh water been considered?
The outlaw of, you mean has the, for use in well stimulation activities? Is that what you're asking?
Right.
I don't know whether it's been considered or not. I would guess it has been. It's not part of the Senate Bill 4 legislation, which was enacted by the legislature and signed into law by the governor in September of 2013. So I don't know whether it was considered or not at that time in the run-up to that bill. It's not currently part of the legislation, of the regulations that are going to be in full force July 1st as required by the legislation.
I've got a question for the Water Board. You've been very proudly touting the fact that no contamination's been identified yet. You've only tested 9
So, you're referring to back last summer when we initially got involved with this, and in the interest of public health and safety, we identified some high-risk domestic, well, mainly domestic. There were, I think, 2 were public water supply wells. But we identified 9 wells that were in proximity to the initial group of injection wells that water board staff went out and tested. However, we have issued information orders to operators, and they have tested the injectate, and they have tested the zone water where the injection is going on. So there's been a lot more testing than that initial group of wells that we looked at.
What's been the result of that subsequent testing by operators?
What you would expect, that the zone water where they're injecting this fluid has a similar TDS to the type of wastewater that's being injected.
So they're contaminated by the wastewater?
No, not necessarily.
It depends on the TDS of the zone water. So, you know, you would have to look at the specific case of that. I don't know if Steve, if you want to add something to that. But so we've required testing from the operators, and water board, the regional board staff has gone out and done some testing as well. But part of the answer is we don't have people that go out and do this. If we think that there needs to be testing, typically we would require the operator to do that testing and not have water board staff do it.
I would like to add a couple comments, because there's lots of water testing that goes on in the state. Your municipal water has to be tested by law, certain regularity. The drinking water supplies in the state are tested quite frequently, and there's, you know, and so at a very high level, if there were a serious problem from oil and gas, we would have learned about it long ago. I mean, we have monitoring wells, for example, in the LA basin. There's a network of monitoring wells that keep track of it, and the preponderance of data shows that the impact of oil and gas has been limited to near zero in terms of drinking water supplies. Your domestic drinking water supplies are tested by various municipal water, and so on and so forth. So there's a lot of water testing that goes on in the state. In fact, well, I'll leave it at that.
Was there any discussion in the early days of this, of ceasing injecting in all these wells that are out of compliance, and then systematically reopening them when they receive the necessary exemptions? And then the decision to follow up, the decision to keep these wells open have anything to do with the potential impacts to oil production in California?
There were a lot of considerations about what the path forward needed to be. Many considerations about our certainty about whether an aquifer is exempted or not. And different people see that differently. So there were a large number of considerations. There were many discussions around that topic and the path that we, including with US EPA. And the path forward is the one that the state decided on. Are there any other questions? Go right here, right in front. Oh, and back.
One, previously you mentioned that the Dogger is working on a technical guidance document to assist the operators in understanding exactly what documentation will be necessary for their application. You indicated April might be the date. Is that still the target date for the guidance document?
April 1 is the target date, and we expect to meet that target. By the way, it's not an operator application, it's a state application to the US EPA.
I stand corrected. The other question is, will you at that same time be providing technical contacts at the division level so that, or at the regional level, so that the operators can in fact prepare the appropriate documentation and application?
Yes, the first stop is the district, is the district, that's
Right.
correct, yes.
There's one word that's really familiar to us lately, we haven't mentioned much lately in this talk, I mean, it's drought.
It's what, a drought,
Drought.
sure.
So as we talk about whether in the future some of these aquifers could be reasonably expected to have potential beneficial use, such as potentially irrigation, as you're now looking at what those, how you're deciding reasonably expected, are we figuring in a longer drought? I mean, we are rather in a pickle here that the same industry that we're talking about, the gas and oil industry, has put us in a situation where potentially because of climate change, this drought may drag on. We understand that we are in new ground here.
Right.
And so we don't know in 5 or 6 years if some of these aquifers, we may look back and say, wow, we're really sorry that we did that because we have ruined something that's priceless. And then as we move forward and we're talking about ending some of this injection by 2016, 2017, we're continuing to move forward and affect these aquifers. The specific question is the drought being figured in? Are you using that as a piece of your criteria? I didn't see it on any of the slides. Going forward and deciding whether it's reasonably expected that these aquifers could be beneficial in the future.
Sure, I mean, I think that is, whether or not a particular aquifer could be reasonably a source of beneficial use is being considered. But I would like.
Are you figuring drought with that? Is that one of the bullet points that goes with that, is my question.
Well, sure, if it can be used, if it can be used in the future, it just, you know, it can either be used or it can't be used. But I would like to do some reframing though. There is the assumption that everything that the oil and gas industry is doing in these aquifers is negative and is polluting and so on and so forth. There's another way to look at that. There's a lot of aquifers in which there's an abundant oil. That oil is being taken out and the water is being returned to that aquifer. And if technology allows it to be efficiently cleaned up for use, you'll have water that's actually higher quality because the oil is gone. So there's this overriding perspective that this is terrible and this has got to stop and so forth. There's actually a lot of situations in which aquifers have abundant oil, and that abundant oil is being taken out and the water being returned to the aquifer in a state that it might actually be considered improved for future use.
So if I could clarify then, you are figuring in long-term, like maybe a 5-year drought, what aquifers we might be going into that we wouldn't normally. You are figuring that in. And more producing of fossil fuels is not actually comforting.
I want to say absolutely we are taking into account drought. That is a big part of it. If you've seen any of the state water board meetings, there are mandatory restrictions that are going on. We're well aware of the depletion of the groundwater basins. That is the biggest issue before the state board now into the future as far as we can see. So yes, that it is addressed, I believe, in our letter to US EPA, our February 6th letter. We talk about the drought. Now in this criteria that we're going, this guidance document, I don't think we're going to list drought. I think it goes without saying, but it's a very big concern, and that's part of what we're looking for in other beneficial uses besides the underground sources of drinking water, and that's why we're raising the bar here to consider that.
Hi. You guys have been talking about the public comment period after Dogger does the initial review, but you haven't said exactly how long of a period that would be.
I forget what it was, 2 weeks? I can't remember. I don't remember. It's not a super long period of time as I remember. I think it's 2 weeks or a month. I'm not exactly sure. Are we out of questions? Thank you very much for your participation.